Welcome to Business Leaders. I'm your host, Dustin Ruge, and today we're joined by Lynda Shely of the Shely Law Firm. Lynda Shely is a renowned ethics attorney based in Scottsdale, Arizona. Amongst many of her awards and accomplishments, she advises over 1,700 law firms, is a current chair of the ABA Standing Committee on Ethics Professional Responsibility, and past president of the National Association of Professional Responsibility Lawyers. Lynda has also assisted the Arizona Supreme Court's task force on the delivery of legal services in drafting many of the Arizona rule changes we're going to be discussing today. Lynda, thank you for joining us today.
Thanks for having me.
Absolutely. Okay, so the topic today is Arizona's recent groundbreaking action to change the rules to permit non-lawyer ownership and investment in law firms and fee sharing. This is a big deal.
It's kind of a sea change for the profession.
Yeah, absolutely. So now, first off, is Arizona the first state to do this?
Arizona is the first state to actually change the rules that regulate the profession to completely eliminate the prohibition against having a non-lawyer have any ownership interest in a law firm. Utah has kind of started a sandbox, what they refer to as a sandbox, a pilot project where they are inviting various entrepreneurs and businesses to come in and give them an idea of how they would like to partner with law firms to provide more affordable services. But Arizona is the first to change the rules.
The first one. Okay, and let's talk real quick about some of the ethics rules, in particular 5.4 and 7.2b. And I'm going to read just some of the rules that would previously exist prior to January 1st of next year. A lawyer or law firm shall not share legal fees with a non-lawyer. A lawyer shall not form a partnership with a non-lawyer. A lawyer shall not practice with or form a professional corporation with a non-lawyer. And then 7.2b prohibits lawyers from giving anything of value to a person for recommending a lawyer's services. All these are gone, correct, as of January 1 for Arizona?
Correct.
Wow.
It's a huge change, and the rules that you just read are the rules that the vast majority of the states in the United States follow. Most states have Ethics Rule 5.4, which says I can't have non-lawyers invest, I can't have non-lawyers as officers or directors or owners. And only the District of Columbia, back in 1991, amended their rule to allow a little bit of non-lawyer partnership, primarily for lobbyists and PR people to join their firms. But this will be the first state to actually eliminate those and allow fee sharing with non-lawyers.
Great. So let's get into the details on that a little bit. So the first thing has to do with fee sharing and referral fee arrangements. And we're going to break these down a little bit as to how they apply to attorneys and non-attorneys with these changes that are coming up. So the first thing has to do with is fee sharing. So tell me a little bit about what fee sharing will look like in January, and what will that mean for attorneys and non-attorneys moving forward?
Well, fee sharing, if it's simply a bonus to an employee, I have a paralegal that has worked with me for years, and I want to give him or her a percentage of the fees that I earn. My law firm will be able to do that. I also will be able to pay somebody for a referral. If another lawyer sends me a case, or a professional sends me a case, a banker, an accountant sends me a case, I will be able to give them a portion of the fees. That fee sharing will not require that my law firm becomes certified as one of these alternative business structures, one of these new entities.
Right, which we'll get to in a moment. So technically then, from the fee sharing arrangement, you could fee share theoretically with anybody except a owner of your law firm, is that correct, or an officer?
I'll be able to fee share with anybody.
Anybody, even outside of a law firm?
Correct. If somebody sends me a case, I can have an agreement with them. You send me a case, I'm going to give you a portion of the fees. Now, there are going to be some caveats there because lawyers still have a duty to protect the confidentiality of everything they know about a client. And that's different than attorney-client privilege. If you are to consult with me, if you say, hey, Lynda, I want to hire you, I can't tell anybody that you consulted with me. So we're going to have to be careful about that, because if somebody has referred you to my firm, I'm not going to be able to say, hey, thanks very much for referring Dustin, because I have to have your permission before I can disclose that.
I see. Okay. Now let's talk about the difference between that and referral fees. So referral fees, traditionally, you cannot pay referral fees to non-attorneys, correct?
Correct.
With these new changes, how is this going to look?
I'm going to be able to pay anybody.
Okay.
And the way I have been describing it, because the rules in most US jurisdictions, and again, I'm qualifying because in the UK, Australia, these rules don't apply. So in the US, I have not been able to pay anybody a referral fee. I could not pay a doctor per client that they send to me. I could not pay the banker $50. I could not pay a website $50 per every lead that they send to me. And that's
Right.
a huge inhibition on, and it's an unreasonable restraint on law firms, because think about all of the online platforms that exist that are very legitimate, that would permit lawyers to have those types of leads sent to them. But now in Arizona, at least, you're going to be able to pay. And as I've described it, that'll be above the table now.
Okay, fair enough. Now, there are some caveats with this, however, when those referrals come in, correct? For example, non-attorneys still can't solicit cases in a way that an attorney otherwise couldn't do so themselves, correct? So
Correct.
the lawyer advertising rules now stipulate that you can't, in Arizona, you can't directly phone solicit or in-person solicit, correct?
Right. So
And those would then apply then to the sources of those leads that come to you as well by referral?
it's right now we're advising lawyers that if you're going to set up a relationship with anybody to have leads sent to you, you're going to be required to let that lead generation person, whether it's a banker, a doctor, whoever, you're going to require to let them know they can't cold call people for you. Unlike the movie Rainmaker,
Right.
Danny DeVito going into hospital rooms, you're not going to be able to do that.
Right, understood.
So that type of, and that's a concern that would be overreaching. We want to protect consumers from somebody coming into their hospital room or
Sure.
bothering them in an ER. There will be some permissible solicitation, though, of business people. That's an exception that's been added to the rules, because if you're a business that regularly hires lawyers to give you business law or trademark law, you probably are okay if you get a cold call from a lawyer.
Sure, absolutely. Okay, good. So just in summary then, so from a fee sharing perspective, you can theoretically fee share with anybody under the safeguards that we talked about, correct?
Correct.
And does that have to be disclosed at all for the attorneys in Arizona moving forward when they do that?
Good question. Clients don't really care.
Okay.
As long as the fee you charge the client is reasonable,
Okay,
they don't care.
got it. And then referral fees, of course, can be now paid to an employee, staff, anybody who's even a non-attorney at this point.
Correct.
Okay, wow. Okay, those are significant changes.
Yes.
You mentioned earlier alternative business structures or ABS models, and that's going to be a part of these changes in Arizona as well. And how will these alternative business structures operate in Arizona, you know, with these changes going into place? And what does that certification process then look like if I want to become an ABS?
Well, the first thing to remember is that if you are thinking about creating an alternative business structure, if you're thinking of bringing in any investors, any innovators, any tech people, and giving them an ownership interest in a law firm, you'll have to apply for certification through the Arizona Supreme Court. And that certification does not mean that the entity, the ABS, can practice law. You're going to be required to do two things. First, you're going to have to certify with the Arizona Supreme Court that you are following all the codes of conduct. You're going to have to disclose everyone in an ABS who has more than a 10% ownership interest or equity interest, and you're going to have to disclose anybody with management authority. So even if you don't give the non-lawyer an equity interest in the firm, you're going to have to disclose if you make them the CEO or the CFO of the firm. That's first. And the ABS is going to be certified and regulated by the Arizona Supreme Court. And the second thing that each of these new entities are going to have to do, they're going to have to identify someone who's an Arizona lawyer as the compliance lawyer. And again, I do the air quotes because we've got regulations that are defining all of this. And there was a lot of concern by lawyers that, oh, well, you know, all the big corporations are going to move into Arizona and they're just going to hire brand new lawyers fresh out of law school. That's not going to be possible, because the compliance lawyer for an ABS is going to have to demonstrate that they have the experience to manage a firm. So they are going to be, they're really going to be in the hot seat. They're going to have an obligation for that whole ABS entity to make sure that everybody is complying with our ethical obligations as a legal profession. So even if I partner with an accountant or a social worker and an engineer, everybody is going to be required to follow certain procedures to assure that they protect client confidentiality and we avoid conflicts.
Now, that compliance lawyer, will that be somebody that has to be on staff, or can they be of counsel to the firm or to advising the firm? What does that look like?
In the draft regulations that exist right now, and understand that Arizona Supreme Court approved these rule changes about 4 weeks ago.
Okay.
And we haven't finalized all the regulations yet, but right now we're recommending that the compliance lawyer needs to be an equity owner in the firm. They can't be some contract person. They can't be, they shouldn't just be an employee, because if the Supreme Court's reviewing that application for the ABS and they see that the compliance lawyer is just an employee and has no equity in the firm, it's doubtful that they're going to have enough authority in that firm to be able to impose all the ethical obligations on everybody. So we're looking at having them have an ownership interest.
So does that mean then that a compliance lawyer, theoretically, the firm would have to be of a certain size to be able to even afford to have a compliance lawyer, correct, as part of an ABS?
I'm hearing of solos
Solos are doing it as well?
who are
Okay.
interested in doing this, and a 1 or 2 lawyer shop, and they want a non-lawyer spouse to become a partner, or they want parents to invest, or they want just their IT people to invest. That's still doable.
Okay. Okay, good. Now, one of the things, just to understand what the ABS structures, right? Will a law firm have to be certified as an ABS to pay referral fees, or is that separate from the ABS?
Referral fees are going to be separate.
Okay, so you still don't have to be an ABS to change with the referral fee models?
Correct.
Okay.
Correct.
Okay, good. One of the other changes that has come across is what are called legal paraprofessionals, or LPs. And, you know, who are these? Are they like paralegals? Are they like attorneys? What is the thinking behind this, and what does one have to do to become a legal paraprofessional?
They are like paralegals and lawyers.
Okay.
Meaning there's something in between, and it's brand new. It is designed to be a professional who will be able to go into court in 4 specific practice areas. It's going to be very limited. They are going to be required to take an exam. They are going to be required to show that they have an educational background and experience to demonstrate they have the qualifications to provide these limited legal services. And really, the LP program is designed by the Supreme Court and the task force that recommended it to deal with this huge access to justice gap that we have. You know, the task force made this recommendation because, based on national statistics, each lawyer in the U.S. would have to give 900 hours of pro bono every year to meet the gap between who needs services and who's getting services. That's
Wow.
not realistic.
Yep.
So the paraprofessionals will be licensed by the Supreme Court. They'll be affiliate members of the state bar. They will have to follow the rules of professional conduct. They're going to be paying into a client protection fund, meaning that if they do something dishonest, this fund will be there to reimburse their clients. They're going to have trust accounts. They're going to have to take CLE, and they're going to be paying bar dues.
Yeah. Now, will they have to operate as part of a law firm, or can they operate independently as well?
They can be independent.
Okay. Wow. Okay.
And it's interesting because a lot of lawyers have expressed concern about this, denigrating our, why do I need a legal degree now if we're letting anybody practice law?
Sure.
And it's going to eliminate lawyers. We kind of heard that back in 2003 when the Arizona Supreme Court adopted a similar change allowing certified legal document preparers. All they do is prepare documents, and we heard, oh my gosh, it's going to be the end of our profession.
Right.
That hasn't happened.
Understood. Okay, so let's get into the why of these changes a little bit right now, and some of them having to do with the reasons why to do this, right? The arguments for these changes. And I want to just read out a couple facts that I've found on the ABA sites and other sources. 100 million Americans cannot currently afford legal services. 80 to 86% of low-income individuals, 40 to 60% of middle-class individuals cannot afford legal services. We know that pro se representation is on the rise. It's stressing the courts, the judges, and the clerks. The National Center for State Courts has indicated that 76% of civil cases now have at least one party that's unrepresented. And then lawyers, which is really interesting, lawyers are spending almost 20% of their time doing legal work, which means the rest of their time is managing their practice, right? So the numbers are pretty compelling. Is that one of the reasons behind this? And what are some of the other reasons that people said this is a good idea and the Supreme Court said let's move forward with this?
Those are all reasons.
Right.
We all recognize anybody, not just in the legal profession, anybody who's had any friend go through a divorce or a bankruptcy realizes that we've priced ourselves out of a certain part of the market. And in spite of that, lawyers are working harder and they're not making as much money. And this task force of the Arizona Supreme Court looked at all of these issues and was really concerned with the access to justice gap, that we're not meeting the needs, as well as the fact that there's a whole bunch of technology out there now.
Right.
That lawyers could use, but they lack the investment capital and they lack the intent to have IT folks and technology people and software people come join their firms and partner with them, either on joint platforms or individually. So all of those factors went into the task force's recommendation that, you know, let's look at all of the rules that regulate the profession and what rules are necessary to actually protect consumers, to make sure that they're given accountable and competent legal services.
Right.
And then we looked at all of that, and the task force concluded that a lot of the regulations that we've had in place since 1985 are outdated, and they're not there to protect consumers, and they're not necessary to protect consumers.
Right. Well, something else interesting I heard was that attorneys are the only major profession in the United States operating in this type of a closed financial system, right?
Yes.
So this is actually liberating legal into what is otherwise a standard for most other professions today, correct?
Absolutely.
Okay, good. Now, what about some of the arguments against it? Certainly there's people that are going to say this isn't a good idea, right? And what are some of the reasons that they're giving for those objections?
Probably the main concern is that if I bring in non-lawyers, if I bring in investment people, all they're going to care about is a bottom line. So they're going to tell me to cut corners, charge more, and not do everything that I ethically have to do. And I acknowledge that, and certainly the task force looked at that, and that's why in Arizona our model is an ABS is going to be regulated and bound by a code of conduct. Disbarred lawyers, convicted felons, people convicted of fraud and misrepresentation are not going to be allowed to own law firms. And there's going to have to be a compliance lawyer. But we looked at all of that, and with that model, we decided this would be the best to provide investment capital to firms and still protect the consumers.
I see. Okay, good. So there are people now, both attorneys and investors, that are going to be looking at this saying, what opportunities are there for me? And one of the things I also wanted to address was some of the rules surrounding investments in law firms, and how can somebody invest, and what safeguards are then in place to protect against those concerns that you're talking about?
Well, when the Arizona Supreme Court eliminated that rule about no non-lawyer ownership in firms, certainly because of the fear I just explained that those evil non-lawyers are going to control me, a lot of the ethics rules were amended to clarify that, okay, hang on. Let's say you wanted to invest in the Shely firm, and Dustin, you also want to invest in the Smith law firm. We have conflict of interest rules that would say, yeah, well, you can do that. You can have an ownership interest in a couple of law firms, but our two firms then can never be adverse. I can't represent a plaintiff against a defendant if you own both of those law firms.
Right.
So we wanted to make sure that there would be some safeguards in place so that you wouldn't have a conflict of interest in any of the owners being on both sides of a deal.
Sure. So similar to the conflict of interest issues that would arise with attorneys would also then apply to the ABS that they're operating under.
Correct.
Okay. Okay. Good.
Yep.
Good. Lawyer advertising rules, the 7s, right? We've talked about many times the 7.1, 7.5. We alluded to 7.2b earlier in the changes there. But what are some of the changes then going to be in Arizona around the lawyer advertising rules? Have they changed? Have they not? And what do attorneys need to know about that moving forward?
Lawyers who are not interested at all in an ABS, lawyers who are not interested in paying referral fees, still need to know that, yes, there's some significant changes in the advertising rules. The main one being we just streamlined them. So the main rule that every jurisdiction in the U.S. uses to regulate lawyer advertising is Ethics Rule 7.1, which says I can't engage in false and misleading advertising. I can't lie. That's going to continue as the main rule in Arizona. And some of the different portions of other rules on certified specialists and when can you use the title certified specialist, that will be continuing. It's just been moved into Ethics Rule 7.1. And the rule about law firm names and what you can use as a law firm name, that's been moved into 7.1 because it all really comes down to it can't be false or misleading. So that rule will continue. And every advertisement in Arizona or affecting Arizona will need to have a law firm name and contact information. And as we've explained historically with that, it's really pretty bad advertising if you don't have those two things.
Right, exactly.
So, and that's actually a change that the American Bar Association adopted a couple of years ago because of what Arizona had done. So now the national standard is contact information, a phone number, an address, an email, a website, something to identify the firm. So those are the big changes in the rules. The solicitation rule we already talked about. You're still not going to be able to go into hospital rooms unless the person in the hospital room is a friend, a family member, a former client, another lawyer, or a business person. So direct face-to-face solicitation is still going to be very limited. And then if you want to send solicitation letters, which a lot of lawyers do in the personal injury area, they'll send a letter, "Dear Mrs. Smith, so sorry to hear that your husband was hit by a bus." Those letters will still be able to be sent, but you won't have to mark them with a big disclaimer on the envelope saying advertising material, and you won't need to send those to the state bar.
Which will be a benefit for them.
Yes, because, well, we have determined because several states have never had those requirements, and they have not had a significant amount of complaints about lawyers overreaching. And the statistics nationally, when we surveyed in 2014, we surveyed lawyer regulation agencies across the country, and we asked them, who files bar complaints about lawyer advertising? Every one of them said the vast majority of complaints that they receive about lawyer advertising are from other lawyers.
Other attorneys. Right. Exactly.
Consumers don't complain about that.
Exactly. Okay, good. You had mentioned earlier when we started our discussion about some of the other changes going on in other states. For example, Utah having a regulatory sandbox and things like that. So what are you seeing now going on in other states, and what could happen as a result of what Arizona is doing, and what other states will see Arizona doing and saying maybe we should do this ourselves?
There are many states now that are starting to create task forces because, of course, that's how lawyers address any change. Whether it's from their Supreme Court or their state bar organization, they're creating groups to look at whether we should change the regulations in their states. California has a task force that is going to be issuing a report in the next year, in 21, regarding possible sandbox pilot programs, again, permitting perhaps some non-lawyers to provide limited services and perhaps to allow non-lawyer ownership in firms. New Mexico has a task force. DC, which has had a different rule for years, is also looking at whether they need to relax their version of 5.4 even more. Even states like Florida, which historically has been pretty conservative in lawyer advertising arena, They have a group that's looking at the regulations. Illinois has some recommendations that came from the attorney regulatory group, as well as from the Chicago Bar Association, Chicago Bar Foundation. Again, also looking at technology issues and how do the rules that we currently live under unreasonably restrict consumers' access to information about the availability of legal services.
Absolutely. Well, there's significant changes, as we talked about. And, you know, 1977, Arizona was the center of the legal universe with the Passions Bates versus Arizona. And it looks like all legal eyes will be back on Arizona again in 2021. All these go into effect January 1st, correct?
Correct.
2021. Okay. So it looks like it will be no different. Lynda Shely, thank you so much for joining us today. If anybody has any questions for you, wants to reach out to your firm, what's the best way for them to do that?
They can go on the website, shelylaw.com.
Okay, excellent. And if you like the show or want to watch additional episodes, please follow me on Facebook, Instagram, Twitter, or LinkedIn, or on my website at dustinruge.com. This is Business Leaders, and thanks for watching.